monogamy, plural marriage, group marriage, or any other kind of marriage between consenting adults. Whether it's biblically based or non-biblically based is not the point of this teaching, is not the point of this dissertation. What is the point is, it is unconstitutional to selectively breed the populace in the United States. It was a power that is in violation of the 10th Amendment, and it is so embedded in our society, and it is so declared to be the law of the land. The law of the land is determined by the people of the land, not by a government, federal or state, that usurps a power to itself that was never given to itself by our founding fathers. Stay with us right here on the RAMYK Channel. We're just going to get deeper and you're going to have a better understanding, and then you're going to share this video and share this program on the channel with others so they can also be set free. And sometimes, again, to expose the nefarious ways of man, you have to expose the ways of man. So again, not every teaching is going to be from Genesis or Deuteronomy or any other book. Sometimes you just have to uncover the darkness before you begin to shed the light. Have the governments of the United States or any of the 50 individual states been granted the power of selective breeding over their citizens or by their citizens? The burden of proof rests upon civil government. Unless someone from government can show us that this power has been given to them, to the government, federal or state, by we the people, or can justify the anti-bigamy laws under some specific power that we don't know about, granted to them by the Constitution, every law prohibiting plural marriage or bigamy is unjust, unconstitutional, and illegal. I'll say that again, is unjust, illegal, and unconstitutional. Unless someone from the government, federal or state, can justify their authority in the areas of social normality and establishing what is and what is not socially acceptable from a constitutional power given to them. And we find no such power given to them. Just the opposite. This power that they've taken to themselves to police themselves and to enter into a polygamous relationship with everyone holding a marriage license. And it's like I shared with you earlier. Don't be deceived. Friends, listen, please listen with your heart. Not just with your ears, but with your heart. Everyone that has a state license is in a polygamous relationship. The problem is the state, Caesar, has replaced Yahweh, the creator of heaven and earth, and you have three parties to your marriage. Your husband, your wife, and the state. So you are in a legal polygamous marriage. The problem is the third party is the state that has come into your life and to your bedroom, and they will dictate who gets the money, who are the heirs, who are the beneficiaries, who are the benefactors, what you can do, what you can't do, what is acceptable, what is not acceptable, what part of your husband's body you're allowed to touch, what part you're not allowed to touch. Watch out! This is where we are today in the United States of America. This is where we are. I said this is where we are. The 10th Amendment to the Constitution reserves all powers not specifically granted by Congress to the federal government or the states back to the people, which is always the case in a territory or especially where no state government exists. The Morel Anti-Bigamy Law of 1862 was and is unconstitutional under the 10th Amendment. Congress was not given the power to interfere with intimate or family relationships or selective breeding among its citizens. In addition, Congress assumed unconstitutional powers by placing the prohibition of plural marriage as a condition for the statehood of the state of Utah as well as other states. All prohibitions of plural marriage placed in state constitutions under federal duress are therefore unconstitutional, null and void. Let me say that again. All federal prohibitions that were forced upon states to gain access to the Union or to bend the states to the will of the federal government are null, void, unconstitutional, can and should be challenged by someone with a treasure chest to overturn these. They are open to overturn. All these, the original Morale Anti-Bigamy Act, as well as the upholding of the so-called legality of that act in Reynolds versus you. All these are subject to overturn and to challenge by those so inclined. And we wait upon Yahuwah to raise up men and women of strength, fortitude, and faith, and fidelity, and conviction, who realize that we, the people, determine how the unit of society, the family, is allowed or not allowed to operate. It is not the government that seizes that power. It is we, the people, who grant that power to them, and not the other way around. The U.S. federal government has no legal power granted by the people to dictate or enforce social normalities or ways of life or traditions. We may not like the way other people are living. We may not approve because of our faith the way other people are living, but they have the right to live that way because our founding fathers did not give the state or the federal government the authority to dictate and tell people how they are to live and with whom they are to sleep with and with whom they are to breed with and mate with. In terms of choosing a mate, limiting a mate to 1 or to 2 or to 3 or to 4 or to white or to black or to Hispanic. They have no authority to dictate who, how many, and how often we mate with. This is at the core of our freedom. People don't understand. This is not just a matter of polygamy being right or wrong, which the Bible, of course, blesses it many, many times over, multiple times over. That's not even the issue. The issue is we're really not free. The Constitution is not being applied to secure our freedoms. And therefore, most of you listening on the RAMYK Channel today think that the law of the land forbids biblical marriage, which it does not. The U.S. federal government has no power granted by the people to forbid any citizen the choice of a spouse, be it interracial, same-sex, which we disagree with, but they do have the freedom to live as free citizens of these here United States, or plural. Now let's get to the 9th Amendment. The enumeration in the Constitution, now we already covered the 10th Amendment, guaranteeing our freedom to live biblically kosher lifestyles. Now the 9th Amendment is the enumeration in the Constitution of certain specific rights that shall not be construed to deny or disparage others retained by the people. Will someone argue that other rights retained by the people and guaranteed by the 9th Amendment do not include the right to choose one's own spouse or spouses without any government interference? Is anyone going to argue? Again, let me read you the 9th Amendment. We already saw the 10th Amendment granted the power to live freely as we choose to the people, not to the federal or state. But now we have a second witness in the U.S. Constitution. In addition to the 10th Amendment, we have the 9th Amendment, which says that the rights shall not be construed or denied or disparaging of the government to others or to the rights retained by the people. Say marriage, family, breeding, the choices, lifestyle, these are all rights that are not only guaranteed, but they are retained by the people. Again, this message, is plural marriage really illegal in the United States? I said, is plural marriage really illegal in the United States? The 9th Amendment has been applied to establish and defend the freedom of intimate association, including the right to bear and beget children outside of civil marriage. Eisenstadt versus Beard, 1972. Can the Supreme Court consistently defend the right of a man and a woman to bear a child while denying them the right to establish themselves together with that child in a family unit? Can the court deny the child the right to a complete family with 2 parents? Suppose a man married with children becomes involved with a second woman and begets a child with a second woman. He has committed no crime under the Constitution. and now has children with 2 women. He has cohabitated biblically.